Thank you. Thank you and good morning, and thank you for being here also. I'm Jerry Hebert with the Campaign Legal Center and the Voting Rights Institute. And I'm really grateful that all of you have chosen to come here on a Saturday morning and hear about voting rights. My colleagues, Julie Fernandez, Justin Levitt, and Leah Aiden, their bios are in the materials. I'm not going to go through that so we can get right to it. I'm going to open the session, but I want to at the outset say that if you have a question or a comment during the course of the next couple of hours, don't hold it until the end of somebody's presentation. We'd rather have a conversation about these issues today, or if you have a question, the only request we have is please use the microphone so we can record this whole session. And we're really looking forward to a lively discussion, hopefully, this morning. So I'm going to begin by thanking the American Constitution Society. And let me just say what a great organization ACS has become and serves such an important need in the progressive legal community. So hats off to ACS and continue great work, and I look forward to being a part of that. And the Voting Rights Institute, which I helped create along with ACS in Georgetown Law School a few years ago. And then, of course, my colleagues, Leah, Julie, and Justin. So I'm going to start by just making sure that many of you who don't get steeped in the details and the trenches of litigation like some of the people up on this panel, we had two major enforcement provisions of the Voting Rights Act. And notice I put it in the past tense. We had to. So we lost Section 5 of the Voting Rights Act. Julie's going to go into that a little bit, so I'm not going to spend much time on it. But basically, Section 5 of the Voting Rights Act covered only certain parts of the country with a long history of discrimination. And that was until 2013 when the Supreme Court decided Shelby County versus Holder, and in that case held that the coverage formula that was used to determine which state and local governments would be subject to these pre-clearance requirements, which are very stringent. I mean, think about it. Every voting change that was enacted in any of the 16 states that affected voting in any way, even in a minor way, had to undergo pre-clearance. Pre-clearance, that means they had to get approval before it could be implemented. And so we'll talk a little bit about that. That was nullified when the Supreme Court struck down the coverage formula as not reflecting current conditions, 5-4. By the way, just a little tip, if any of you are interested in going to the U.S. Supreme Court in a voting rights case, please let me know. I will, this is a spoiler alert, however, I'm good at losing cases 5-4. So, anyway. Section 2 of the Voting Rights Act is a major enforcement provision. It's still in effect. It applies nationwide. It's supposed to be permanent. I suspect it will be until John Roberts gets 5 votes to strike it down. So these are the states that were covered. The ones in black are covered in their entirety. The ones in red were partially covered. So you can see that the places with a long history of discrimination really were targeted by the Voting Rights Act, and it was actually demonstrated to Congress that these were the places that continued to have the problems, and yet Congress, the Supreme Court, kind of acted as a super legislature, which I don't think John Roberts said in his confirmation hearings he was going to do, but we'll leave that for another day. So Shelby County came down. Until Shelby County, as I say, they had to show that every voting change was non-discriminatory in both purpose and effect. That's pretty, and they had the burden of proof, which is like getting an instant injunction, right? I mean, even before they have the burden to overcome the fact that whatever voting change they were going to propose is free of a discriminatory purpose and effect. And they had to go to the Department of Justice for preclearance, or they could go to the D.C. court. All that changed, however, after Shelby. And in fact, Leah Aiden's going to, when she gets up and speaks, she's going to give us a rundown of some of the problems that have happened post-Shelby, and you can see what impact that had. But here's the basic holding in Shelby County. And Zach, these slides, we'll post them at some point, right? So, great, okay. So, as I say, the 5-4 decision struck down the coverage formula, renders preclearance a nullity because if no jurisdictions are covered anymore, preclearance, which is Section 5, really is ineffective. The Supreme Court did note, however, this goes to show you how politically acumen the Supreme Court is. They said, well, Congress could always change the Voting Rights Act. And of course, this Congress is really not divided at all when it comes to voting rights and election law issues. So look forward to that happening. So we'll see if they can repeal and replace Section 4, just like they do so many other things. The court said the formula was 40 years old and was seriously out of date and did not reflect current conditions. And Section 2 has been left intact for now. So here is what Section 2 is, and I highlighted in red. It's it's kind of a long statute for a statute that simply says you can't deny or abridge the right to vote on account of race or minority language provisions. But it's a results test, so you don't have to prove intent. When you go into court, that's you going into court, suing under Section 2 of the Voting Rights Act and saying this voting practice or procedure or requirement results in discrimination. And as you can see in red, there's things I highlighted. They look at the totality of the circumstances. You look at it applies to both primary and general elections. You have to show essentially that the protected minority group, racial or ethnic minority group or language minority group, that the processes leading up to nomination or election are not equally open. And oftentimes in redistricting cases or challenges to multi-member districts, for example, you look to see whether members have effective representation commensurate with their share of the population. I listened to a story on NPR this morning about a city in Illinois that was about 50% Latino, and they had one representative on the city council there of about 7, which struck me as disproportionate, and maybe there's a problem there. So Section 2, just to highlight, it's a nationwide statute. There's a results test. You look at the totality of circumstances. There's a case called Johnson versus DeGrande where that comes into play. And it applies to both vote dilution cases, where you challenge multi-member at-large elections, or you can challenge redistricting plans. And again, you can also challenge vote denial cases, like photo ID cases, of which I have spent the last 6 years litigating. So the impact of Shelby, I just want to give one example, which is Texas enacted redistricting plans for Congress, State Senate, and State House in 2011. The then Attorney General of Texas, Greg Abbott, how many people from Texas, by the way? Oh, that's too bad. I'm sorry.
A lot of work for all of you.
I'm so sorry. So Greg Abbott announced that he was going to be damned if he went to the Obama Justice Department for begging for preclearance. So he decided to go to the D.C. court, where he thought he would find a more friendly audience. I wouldn't take advice from Greg Abbott about who's going to win the Belmont Stakes next week, because he made a bad choice. I mean, a bad choice. A nasty woman-type choice. So he found that, the court found that all 3 plans discriminated against minority voters. And I just want to highlight 2 things. You know, electronic discovery is so valuable in these cases. So we were able to get emails. And my favorite email was the nudge factor email. And I never heard of the nudge factor email. Now, I've been practicing law for 45 years, which is a long time, and all in voting rights, pretty much. So, and I had not heard of the nudge factor. And neither had the person who received the nudge factor email. So the person said, the person who wrote the nudge factor email said, when we go to redraw the Latino congressional district down from San Antonio to El Paso, let's make sure we employ the nudge factor. And the reply was, I'm not familiar with the nudge factor, which I was so happy to see. And then I saw the reply, and it said, well, here's what the nudge factor is going to do. We are going to take the minority district, which is currently an effective district, and electing a Latino who is the candidate of choice of Latino voters, and we are going to look around the edges for high turnout voting precincts, and we're going to take those out, those high turnout Latino precincts, and we're going to replace them and put into the district Latino precincts that are lower turnout, but have the same percentage of Latinos in it, so that but there'll be lower turnout. We know this from past elections. And so that way we can nudge the district from being one where Latinos are electing the candidate of their choice to one where white Republicans can elect the candidate of their choice. Now, that's about as close as you can come to a smoking gun. In fact, I called it a smoking gun in my closing argument to the three-judge court. The other one was a no bueno email. So here's the other. So in the state Senate, I represented Senator Wendy Davis in the case. They liked Wendy so much they divided her district 5 ways, okay? And so she didn't have a place to run after they drew the redistricting plan in 2011. So we tried to block preclearance of that plan, and we were successful. And the court found not only that it violated Section 5, but that it was purposefully, intentionally discriminatory against minority voters in the way that they divided her district 5 ways. But my favorite piece of evidence in the case, aside from Wendy's testimony, which was pretty awesome, was about how effective she was at representing minorities and why the district was not her district, but one that was important for minority voters that she represented, was the no bueno email. Now, again, I'm thinking, okay, that was the subject of the email. So I thought, wow, that's interesting. I wonder what was no good. Well, it turns out that the chairman of the Senate Redistricting Committee said, we have a committee hearing coming up. It's the only committee hearing where we're going to hear about proposed plans for the Senate. Let's go ahead and write the committee report now before the hearing so that we can speed up enactment of our plan, because we know we don't really care what anybody says at the committee hearing. After all, they're just going to present alternative plans, and why would we care about those? We have our own plan that gets rid of Wendy Davis. So the lawyer for the Senate Redistricting Committee and the Texas Legislative Council wrote back, no bueno. And then he explained, the reason it's no bueno is because all the committee reports, if you type them up, get time-stamped in the state's computer. So they will know that we've done so in advance of the committee hearing, and the Justice Department will hang us when we try to get preclearance. So you can see how states really paid attention to preclearance and the non-discrimination provisions. So anyway, the three-judge court ruled against the plan, and then when the case was on appeal, of course Texas appeals everything, and they go to the Supreme Court, and while that's pending, the Supreme Court decides Shelby County, and that kind of nullifies the DC court's ruling because they had blocked approval of these plans under the preclearance provisions, and so Shelby County kind of nullified that. And so Greg Abbott tweets the Attorney General immediately, the plans are now going to be in effect because Shelby County came down. So we immediately had to go to court, back to court in San Antonio, and bear the burden of time, inertia, and cost. And that was in 2014, 2013 when Shelby came down. So we've been litigating the redistricting plan since. You can see how much time and effort these take. We go to trial again for about the 3rd time on July 10th, coming up next month. So one thing the court did on remand, though, is it found that Texas's plan that the DC court had blocked was also intentionally discriminatory under Section 2 of the Voting Rights Act and the 14th and 15th Amendments. So now we're back to the state then adopted an interim plan, so we're back trying now the interim plan. So the other example is the photo ID law. This is my favorite. Texas passed a photo ID law in spring of 2011. It got blocked by the DC court in 2012. Shelby County comes down in 2013. And again, finding that the law was discriminatory in its effect, several 100,000 people who are registered to vote in Texas lack the photo ID. And Texas was really good at picking and choosing which IDs they could use. They picked IDs, for example, that predominantly were held by whites, like license to carry a firearm in Texas. That's okay. Student ID from the University of Texas? Not okay. FBI, federal ID? Not okay. State employee IDs? The very legislators who enacted the intentionally discriminatory photo ID law can't use the ID that they have to get into the legislature to suppress minority voting rights as an opportunity for them to go to the polls to vote. So the DC court strikes it down, stops it, and then when the Supreme Court decides Shelby County, he says, okay, I'm going to, it's now in effect. Now, I don't know about you, but if you were the Attorney General of Texas and a federal court had found that the law was discriminatory, and the Supreme Court vacated in another case part of the Voting Rights Act, but it didn't affect the substance of your law. Your law is still what it is, and a court has found it to be discriminatory. Would you just say, oh yeah, okay, well now it's in effect, even though it's discriminatory? Or would you say, maybe we should go back and look at this? Well, that's Greg Abbott. So I want to distinguish between voter fraud and voter registration fraud, since we're talking about photo ID cases. Now, voter registration fraud, you may have heard about the Acorn scandal of a few years ago, where they would submit, some volunteer would submit Mickey Mouse, for example, okay? So that's voter registration fraud, but there's never any evidence that Mickey shows up to vote, okay? That's voter registration fraud. Even though they submitted fictitious names, there was never any proof that any of the fictitious people voted, as opposed to in-person voter fraud, where somebody actually shows up to vote. So if Mickey does show up, this is what Mickey looks like, and I think we all would know that that's Mickey. Okay, so if you ever hear about Mickey voting, let me know, because it's never happened yet. Mickey's never shown up. So why don't people commit in-person voter fraud? This is the big myth that's out there. Because no election outcomes, first of all, have ever been shown to have been changed with one in-person vote. It's irrational to commit in-person voter fraud to change one vote. Think about it. If I'm going to pretend to be Justin Levitt and I go to the polls to vote, I first of all have to hope that they don't know who Justin Levitt is. Because if they know who he is, they know I'm not him.
If you're pretending to be Justin Levitt, you got a whole bunch of problems.
Well, we can stipulate that I have a whole bunch of problems. But so that's problem number one. Problem number two is I have to hope that they don't know who I am, because if they know who I am, they know I'm not him. Then I have to hope he hasn't voted yet, because if I show up at the polls to vote and he's already voted, they're going to know, hey, something's up. And I'm going to commit a felony with a 10-year prison sentence and $10,000 fine for one vote. I mean, it makes no sense in front of government officials. That's why this claim of hundreds or millions of illegals voting, I mean, the last thing they want to do is go in front of a government official and say, okay, hey, here I am, I'm illegal, and I think... So it makes, I think voting in person to commit voter fraud makes about as much sense as forging a Bed Bath & Beyond certificate. It makes no sense. Who would do that? Anyway, I can't have a voting session, I can't really go into a voting rights session without talking just about two slides that Greg Abbott used. Now, this was his training. Now, before they enacted the photo ID law, what they had to do is go around the state and say, voter fraud is rampant. We have to really stop it because, oh my God, if we don't stop it, the democracy will fall and this will be, you know, he was like the Chicken Little running around everywhere, voter fraud, voter fraud. And there had never been hardly any examples in 20 years. I think there were 2 examples of in-person voter fraud, and they were both kind of situations where a father voted and they marked the son's name, the son's name, and the son voted and the father. Or a woman voted for her mother and her mother died, but she took her absentee ballot and sent it in. So there were very few examples, even though there had been tens of millions of votes. But Greg Abbott goes around the state. This is his PowerPoint, and tries to train all the district attorneys in the 254 Texas counties what to look for voter fraud. Now, there's this myth out there that voter fraud is rampant, right? So, and there's also that the claim is that, well, we're doing this to protect the integrity of the election process. People have to have confidence in the elections. And the people who actually sponsor these vote suppression laws claim that there's no race, really not a racial element to this. It's all about the integrity of the ballot and confidence in elections. So so he then says, well, you got to watch for people who show up at the polls because they commit fraud. And he actually showed us a picture of who they are. And do you see any white people in that picture? So apparently Greg Abbott thinks that the only people who commit early voting fraud in person are African Americans. But that's not the end of Greg Abbott's racist slides. He also says you have to examine documents for fraud. You got to, like mail-in ballots, you got to look for obvious signs of tampering, hence the Scotch tape there. You know, somebody opens the envelope, mismarks the ballot, then seals it, and then has to use tape. Some handwriting on the form might be different, so you got to watch the handwriting. But my all-time favorite, he says, the people who commit voter fraud use unique postage stamps. Now, do you think it's the American flag postage stamp that he's going to put up, or something, you know, a forever stamp? No. That's the stamp he showed. Now, you had the same reaction the three-judge court did when we tried the photo ID case. It was like, oh my God, really? All right, final thing I want to talk about are partisan gerrymanders. You know that the Supreme Court, perhaps in 1986, you know that the Supreme Court held that political gerrymandering cases could be adjudicated. The plaintiffs had to show discriminatory intent. That's usually pretty easy. In redistricting, the Republicans always say we're out to get the Democrats and maximize Republican seats. Democrats do the same thing. So this is a bipartisan issue. And it's fairly easy to show that. Discriminatory effect, however, was hard. So in 2003 and 2004, we brought a case in Pennsylvania. Paul Smith and his team at Jenner and Block, we brought this case in Pennsylvania. And we ended up in the Supreme Court. It's another one of my examples of losing 5-4. 4 justices would have overruled Bandemer and said you can't even bring partisan gerrymandering cases. Then you had 4 justices who said, yes, you can, and we have a new test for measuring effect, and here it is. And then you had Justice Kennedy, who was like Goldilocks. He couldn't quite find the porridge that was just right. He said, look, I don't agree with you 4 who say that, we should overrule Davis and say these are non-justiciable, but I also don't agree with these other 4 tests yet. But I have some ideas about that, and so he laid out his ideas about how he thought a partisan gerrymandering claim could be read. That was in 2004. We're now in 2017, and the Supreme Court has yet to justice the issue, so we're still waiting. Now, a test, we came up with a test because when we read Justice Kennedy's concurring opinion in Veith, we said, hey, we think we have an effects test that uses partisan intent, partisan effect, and that the partisan effect can be shown not to be justified by adherence to traditional redistricting criteria. And we found a professor, Eric McGee and Nick Stephanopoulos, who had come up with a test called the efficiency gap. So here's how we prove effect. How do we identify a partisan gerrymander? Well, all gerrymanders rely on one or both of 2 techniques, either packing people into a district or cracking them between 2 districts. Packing and cracking. So here's an example. You got 50 precincts. 40 of them are percent are teal and 60% are blue. You got 5 districts, and here's one way to draw them. So you can draw them, even though the teal group is only 40% of the electorate, you can configure the districts the way you draw them to make sure that teal wins 3 out of the 5 seats, even though they're only 40%, by basically cracking the blue group and then packing them into one district. As you can see, here are the packed districts down there, 4 and 5, and then you kind of waste their votes that way. So that's how you can combine cracking and packing. So when I say wasted votes, the efficiency gap that this test we've come up with, looks at surplus votes. So you take the number of districts in a state and you look at how many votes were cast by the winning and losing party in that district. Now, all the votes cast by the losing party, a Democrat and Republican run, and one guy gets 60, the other woman gets 40, so those 40 votes are all wasted because they didn't win. Every vote above 50% for the winning candidate was kind of wasted because they only needed 50% plus 1 vote. So you kind of add up all the votes in that way under the efficiency gap. And you can identify, and this chart will be available to you, you can actually identify where the wasted votes actually come from and look at how many surplus or lost votes there are, and then you do this calculation, which actually is about a 6th grade calculation. It's really not hard. You take the one party's total lost votes, and then you have the blue parties, the losing parties' lost votes or surplus votes, divided by the total votes. And in my hypothetical, I've come up with 47 divided by 198 over 500. Subtract 198 from 47, divide it by 500. You get an efficiency gap of 30.2. And an efficiency gap of 30.2 means that the Teal Party is getting about 30% more seats than one would expect under a fair plan. Now, the efficiency gap, I don't know if Justice Kennedy's going to like it when it gets up to the Supreme Court, but we filed a lawsuit using the test in 2015 over the Wisconsin General Assembly plan. And three-judge court was convened. They denied Wisconsin's motion to dismiss. Basically, Wisconsin said, yeah, these issues are non-justiciable. And then they lost a motion for summary judgment, and so we tried the case last May. The court ruled 2-1 in our favor, and not a liberal court, by the way, and we won 2-1. They found it was an unconstitutional partisan gerrymander relying on the efficiency gap. Now, these are three-judge court cases. They go directly to the Supreme Court. They don't go to the Court of Appeals. State has filed a direct appeal to the Supreme Court. We have filed a motion to affirm. It was set for conference Friday, this past Friday, so we may know Monday. We do expect the court to take this case and set it down for merits briefing over the summer, and we'll argue it in the fall. The state, by the way, after waiting 7 months after the decision, now has just filed recently a motion to stay remedy proceedings. The three-judge court had unanimously told the state to come up with a new plan by this November for use in 2018. But the state has now asked for a stay. We filed an opposition, and that was conferenced on Friday, so we'll know the results of that. We believe the Whitford decision, this case that we won, it reads like a love letter to Justice Kennedy, responding to the views that he expressed in Veith, so stay tuned on that. I'm going to stop there because we'll be talking about the President's Advisory Commission on Election Integrity. I put integrity in quotes just for all of you who follow these issues closely. You'll know why I did that. So I'm going to stop there and turn it over to Julie, and Julie's going to provide kind of context for all of why we end up talking about, why in 2017 we're still talking about protecting the most fundamental right we have as Americans, the right to vote. Julie, thank you.
Okay, I'll see if I can do that. Hi, good morning, everybody.
Good morning.
So I'm going to see if I can do what Jerry said I'm going to do. First, I do want to just thank Jerry for putting this panel together and asking me to be here, even though it's Saturday morning, so I'm kind of opposed on many levels to being anywhere Saturday morning at 9:15. But here I am, and I'm happy to be here with Jerry and, of course, Justin and Leah also. So I do want to take a minute to sort of to step back and talk about what are we talking about, and then move on to sort of do a little bit about where I think we are right now and the challenges that we're facing, and what I think we need to do both as lawyers but sort of as citizens to understand where we are and to get engaged to kind of to push back in a way that could be, that I think is really necessary. So first, how did we get here? Jerry touched on a little bit of this. I just think it's important for us as we go in this voting world to remember that this fight that we're in, the fight around how do we achieve equal political power, is as old as the Republic. This is not a new fight. We have to just, it's helpful for me to remember this is at the founding of our country. Who could vote, right? White men of property. Then we sort of had different sort of stages along the way where we have expanded the electorate, and then we've contracted. And we've expanded and we've contracted. It's been fits and starts the whole way. So we're part of a long tradition of people who are trying to move things forward in the aggregate, knowing that we're always getting pushback. And why are we always getting pushback? Because what is this about? It's about who has power. And people who have power are the ones who get to decide who else gets power, right? So they're going to be very cautious about who gets that power because it's going to impact their own. And I don't mean this to be cynical, I just mean it to be real, because that's what we've seen in our country. So when women got the right to vote, I mean, many people don't remember that Native Americans didn't actually have a protected right to vote until the 70s in this country. We know what went on with African Americans, and we know what went on with Latinos, but we need to remember this. So one of the big sea changes in this march toward equal political power was the 1965 Voting Rights Act, as Jerry talked about, with the two very powerful provisions, but it also outlawed poll taxes. Part of what the VRA did is it outlawed literacy tests. It was this idea that we were actually going to protect a group of voters, a group of citizens who were deliberately locked out of any political power, and we're going to protect them from being intentionally and having laws that have the effect of knocking them out. So they kind of got a protection that other voters didn't have. And that's what's also kind of interesting about the Voting Rights Act, because it kind of said, because of how badly the system has been in vis-a-vis African Americans first, and then after 75, Latinos more explicitly, because of how bad the system has been, we're going to specially protect you getting screwed with. And that's what the 65 Voting Rights Act did, and it was a revolution. It was an actual, real revolution. It's a great book called The Quiet Revolution in the South, right? But it's because it's real. This idea that all of a sudden African Americans, I mean, even the founding of our country and the constitutions built in there this idea that we want to count African Americans for purposes of like the census so we can get our congressional seats, but we don't want them to actually vote. Right? We want to count them for when we need them, but we don't want them to actually participate.
And part of it, we want to count part of it.
Yeah, we want to count 3/5. Thank you, Leah. We want to count part of them to get us the number of seats that we think we deserve, but of course we can't let them participate. So it was a revolution, and it provided this sort of additional protection. And as Jerry said, part of why Section 5 was so critical is because it recognized that what had been happening prior to Section 5 of the Voting Rights Act is that people were challenging these racially discriminatory voting practices, and sometimes they were winning, but then the state would just enact another law that's very similar to that right afterwards. So it was the game of whack-a-mole. You kill one law, a new one grows. You kill one, a new one grows. And so you had to kind of have lawyers and time and energy to keep that going always, because the discriminators were always one step ahead of voters. Mm-hmm. So that's why it was so important. So that was the Voting Rights Act. But we also, another important sort of revolutionary moment was the NVRA, the National Voter Registration Act, passed in 1993. And what is interesting about the NVRA is that the NVRA actually was passed by Congress prior to 1993, but vetoed by George H.W. Bush, the first Bush. Why did H.W. Bush veto the NVRA? What was the NVRA about?
It's a motor voter bill.
It's about voter registration. It's about increasing voter registration by citizens. It was, as you all know, it sort of put requirements on states to offer and assist people in registering to vote, both when they're at the Department of Motor Vehicles, because the idea was that a lot of people are going there to renew their licenses, they have your information anyway. But it also, and the more controversial part, was it also required states to offer voter registration opportunities and assistance at social service agencies. And it was purposely done in that way to reach lower income people. Because the idea was that a lot of people who are low income, and we should be ringing bells around what's happening now with voter ID, don't have driver's licenses. And they don't have driver's licenses that are up to date. And their addresses change, because poor people move more than people who are not poor. Right? And things expire, and they also get tickets. They get speeding, everyone gets tickets. I get tickets. So you get tickets, but then you can't pay your tickets. If you don't pay your tickets, you can't renew your license. So a lot of folks drive around without a valid license. So the Congress knew that, so they said this is not just going to be about DMVs, it's also going to be about social service offices, disability offices, welfare offices, and that's the controversial part. So H.W. vetoes it. The first bill that Bill Clinton signed into law when he became president in 1993 was the National Voter Registration Act. There were 6 Republicans in the Senate that voted for that bill, 6. At the time, there were only I think there were fewer than 40 Republicans in the Senate, but only 6 of them voted, and none of those folks, I'll tell you today, this is not a partisan statement, none of those folks would be Republicans today. It was like Bob Packwood, Arlen Specter, who became a Democrat, folks like that. Because the whole party has changed. We all know that. This is not about political parties, but it did happen. The NVRA was huge, and it was because it also kind of engaged in this very public debate about it put the responsibility on government to make sure the citizens could vote, were registered to vote, and that was controversial. The next sort of watershed moment in our march toward where we are now is Bush versus Gore. Folks, remember that? I do. Remember the 2000 election? It was shocking. So what was shocking about Bush versus Gore? There are lots of things shocking about Bush versus Gore. The thing that I think was most shocking for what I'm talking about was that people woke up to realize that fewer than 600 votes determined a presidential election. those of us who have worked in voting for a while, even prior to 2000, understood that voting is messy sausage making. It's run by volunteers in, schoolhouses with paper and pencil, and it's all a mess. And you kind of think it all sort of comes out in the wash. You want good rules, you want enforcement of good rules, you want protection of vulnerable groups, but it all kind of comes out in the wash. But 2000 was, hold on a second. Voting rules, the message that went to political parties and those in power was voting rules matter a lot to who wins elections, like big elections, like presidential elections. And these small number of votes, if you can influence the margins, you can influence power. So we just have to win at the margins. If we can disenfranchise this few number of votes from this community, we can win big. Other watershed moment I have to say is 2008, when Barack Obama was elected president. I think that it is true that many people thought that was impossible because he is African American. Just say it out loud. And they thought it was impossible because they did not believe that there was an electorate out there that would elect him. Lots of people believed that. And when it became true that there was a real multiracial coalition with a bunch of young folks in it that was going to elect Barack Obama, and it was multiracial, and it was, that's going to happen, people flipped out. We know they flipped out, right? They flipped out publicly on Fox News every day. They flipped out every day on Fox News about the fact that Barack Obama was actually elected. They really part of it is as if their minds couldn't compute it. It's like there's like a do not compute in a computer. Like, what do you mean? That couldn't have happened. But it did happen, and it also sent a message around, remember, we can influence elections at margins, and this electorate is one that we are not happy with this electorate. Let's figure out what we can do about it. And I do find it interesting that Obama was elected in 2008, and 2009 was the decision in Crawford. Crawford is the voter ID decision out of Indiana, where the Supreme Court essentially said, it was a fairly strict voter ID law in Indiana that was facially challenged. So the allegation was, the complaint said it was unconstitutional in every application, right, because a facial challenge, but it was prior to it being implemented, so there was no evidence of impact.
And it wasn't a voting rights case.
No, it wasn't a voting rights case.
Voting Rights Act case.
It wasn't a Voting Rights Act case. It was a facial constitutional challenge. So they lost, and part of what the Supreme Court said is like, what's the harm here? What's the harm here? I don't see it. Now, of course, Judge Posner, who was on the Seventh Circuit and was part of the panel decision, subsequently has said, oh, now I see this as political manipulation. But at the time, that case had not been made. So Crawford. And then, of course, 2013, we have Shelby County versus Holder, which Jerry talked about as invalidating the formula that determined which states were subject to the Section 5 preclearance requirements. So all this is to say that we've been sort of, those of us who are fighting for equal political power have been at war for a long time. And it's been accelerated, I think, since the 90s. And I think that that's where we are now. And we're at a moment where, and I just think an interesting observation is that prior to Shelby County being invalidated, a lot of the wars over this access and voting laws were northern wars, right? They were Wisconsin, they were Indiana, they were Ohio. 2004, remember 2004, Ohio, all this litigation? That's where it was. It was a northern war. Why? Because Section 5 was protecting the South. And I have to say, when Section 5 operated, it wasn't just protecting minority voters, because when you have a preclearance requirement where you have to make sure that the laws that are passed are not, don't have a discriminatory purpose or effect, you're also having sunshine on the whole thing. So you're kind of looking at the whole thing, and even though you can only interpose an objection if you can determine it meets the requirements of Section 5, it's still like it's a sunshine thing. And people are debating the impact of your law. And they're looking for, and they're also Section 5 required inclusion of community members. So one of the questions that we would ask, because I used to work in the Justice Department, one of the questions we would ask is, who have you talked to in the community? What's their phone number? We're talking to them too. So you necessarily have a process where you're like engaging with the community as a law enforcement person. So that was very important. But as soon as Shelby County happened, and this sort of protective cone, which wasn't perfect, but it certainly served a big purpose over the South, and the Southwest was lifted, the war goes right to the South. Not just Texas. Texas, North Carolina, you know, where the federal courts have said that the legislators in North Carolina were discriminating against black voters with surgical precision. Surgical precision. I see Kathy Mesa out there. Kathy Mesa, surgical precision. Kathy knows. She was litigating this case. So that's what was happening. The war went right to the South and the Southwest. It had always been. I have to say about Texas, though, just one thing. You know what Jerry talked about, what happened in the 2010 round in Texas in CD 23? It's the exact same thing that happened in 2001. Because Texas, you Texans, you know, Texas is bold. You know, they're out there. They did that exact same thing after the 2000 census.
Yeah, they just hadn't called it the nudge factor by then.
They
But
did the
in
exact same
2001, they did the exact same thing. They diluted the same district.
And in the same way, let's find the low turnout Latinos and swap them in for the high turnout Latinos. Did the exact same thing. So anyway, so I think so. Right. So where are we right now? So I'm talking about where we've been, but I think it's helpful to me when I try and remember all of this. So where are we now? We're winning in some ways and we're losing in some ways. So we are winning in some ways because we have awesome litigators, and hopefully we can have more that are engaged in the war in the courthouses to try and get victories to help establish legal standards in a post-Shelby world about what the VRA can do, what the Constitution can do, what other statutes can do, which Justin will talk about. And the fact that we have big wins in Texas so far and wins in North Carolina is incredibly important. But again, because we lost Section 5, we no longer know a lot about what's happening in other parts of the country. So we know about Texas, Northern North Carolina, but there are counties and towns and villages and cities across the country. When Section 5 was operable, something like 85% of all of the objections, all of the blocked changes, were not statewide. They were local. They were county. And some counties are big, right? When you see counties, sometimes people think, oh, counties, what's that? Counties are huge, and they have tens of thousands, sometimes hundreds of thousands of people, and that's kind of where the game is. The Section 5 Voting Rights Act game is at the county level, and we don't know about that stuff anymore the way we used to. They used to have to submit everything, and now we don't know very much at all. So that's how we're losing. We just don't know as much. And even if Jerry's lawsuit goes forward and they invalidate these two terrible, the Supreme Court allows these two things to stay invalidated, the ID law and the redistricting plan, there's no guarantee at all that the court is going to impose preclearance on the state to have to preclear future changes. And even if they do, my bet is they do it for statewide only. So Harris County can still do whatever it wants. Bexar County can do whatever it wants. They're all still out there able to do whatever they want, and you have to sue them afterwards. We're also winning that some states are passing these sort of convenience measures, online voter registration. Some are doing expanding early voting. Some are doing election day registration. My favorite is same-day registration in the early voting period, but whatever. But how are we losing? That's the one I'm going to finish talking about here. How are we losing? We're losing because we've lost the narrative. We have lost the narrative. And if we don't win the narrative back, we're going to lose. For those of us on the side of wanting to have equal political participation are going to lose the game. So what do I mean by that? I mean a lot of what Jerry was talking about. What is the conversation that we're having? The conversation that we're having is, how much fraud is there? How do you prevent fraud? Does this measure prevent fraud? Is there really fraud? Fraud. That's the conversation we're having. And our side is like, well, there isn't as much fraud as you say. There's less fraud. There's only this kind of fraud. That thing won't stop fraud, and our thing will stop fraud. Fraud. So that makes everybody think that that's the issue. How do we have voting rules that stop fraud? Friends, if that's the issue, we lose. Because if that's the problem we're trying to solve, then the only solutions we have are solutions that fit that problem. Is that our problem? Is our problem how much fraud there is? Donald Trump says it's 5 million people, and we say it's only 10,000, or it's only this type. No, we don't win that. And the American people, they think that there is voter fraud. And I'll tell you, we have done so much research, polling, messaging, blah, 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 blah. You're not going to get them off that. If you're engaging them in the fraud conversation, we're never going to win. So we have to change the conversation. We have to talk about something else. What can we talk about that allows us to have a framework for what we really think is important? What do we think is important? What do the people also believe? The American people believe that there is voting fraud. There may not be that much of it, but there is some, so why don't we try to deal with it? But they also believe that we have a right to vote. They believe we have a right to vote, that we have it and it's important. So we need to find a way to capture that and frame it in a way to say, you're right, we have a right to vote, it's super important, and here's how we protect it. Here's how we protect it. We protect it the way we protect the right to bear arms. Everybody knows the NRA, right? Right. So what's the NRA's theory about the right to bear arms? What's their theory? Every restriction is on a slippery slope toward you're taking away my right. Everything, I challenge every restriction with the lens of it's a fundamental right to bear arms, and I pass no judgment. This is their theory, and it works. I don't want to copy it. Everything you do you have to have a damn good reason for doing it, and it has to be really, really minor, and then I'm still going to fight you to the end, right? No compromise. That's not how we are. We're death by 1,000 cuts. Right? Because we have registration and 35 days before or 60 days before. Okay, I'm going to stop. 54 and 60 days before, and then you have to have this ID but not this ID, and then you have to bring your mother and your dog and this and that. It's like 1,000 things, and every little thing seems rational, right? To a lot of people, it's rational. Add them up, and we get a bunch of folks that can't participate in the electoral process. So how do we... And one thing I just want to say too, just because about this whole idea, Jerry's picture, I'd never seen that picture before about the stamp and all that. It's nuts. But part of how they are framing the fraud, we have to acknowledge, obviously, an obvious fact, that we all walk around with a lot of bias and a lot of racial bias, a lot of ethnic bias. We all walk around with it. We do. It's in our brains. Take one of those online bias tests. We all fail. Because we live in America, we watch TV. We can't help it. So we all have it. And what happens is that this narrative about fraud triggers racial ideas in people's heads. That's what he's playing to, right? Because our unconscious or conscious bias is triggered when you say fraud, because part of the discrimination, the racism that's in all of our brains is that African Americans and Latinos are less honest. It's in our brains. I mean, I don't mean this is not an indictment. It's in there. And so they're triggering us when they use this kind of language. It's like, you remember that time when Jesse Jackson said, maybe you don't remember, but I remember this. And Jesse Jackson said, well, when he sees a black guy on the street, he pulls his purse, he crosses the street, understands why women pull their purses closer. I mean, totally racist statement. But what he was saying was that this unconscious bias makes him think maybe he's a criminal. Right? It's the same kind of thing. So they're playing to that unconscious or conscious racism. But anyway, so we have to acknowledge all of that and say, so that we're not going to have that fraud conversation because it's fraught and we're losing it. We're going to talk about the right to vote. How do we protect it? How do we make it so that everything that legislatures do has to be subject to the kind of test that we have for the right to bear arms? How do we do that? I have lots of thoughts. And we're trying to come up with a way to have thinking about how to come up with a national campaign that will have activities in the states around pushing for state legislative action that better protects our right to vote. We don't need you to give us one. We already have it. How are you protecting it? And lawyers in states, this is still like a small child, not even a child yet. It's just an idea. But if it is born, which I think it will be, we'll need help from lots of folks in the states to help us figure out how to think about how to take this broad narrative and apply it in a number of states around the country so we can have a movement that's an affirmative movement about something that we all care about that allows us to talk about voting in a way that makes people feel good and positive and then meets our goals to create equal political power. Now I'll stop. Sorry.
Thank you, Julie. One of the things that Julie just touched on towards the end, I want to call attention to, which is how do we, in the jurisprudence, change how we analyze restrictions on the right to vote. Now, the right to vote is supposed to be a fundamental right. So let's look at the campaign finance decisions of the Supreme Court, Citizens United and McCutcheon and all those. They say that, corporations have a First Amendment right to spend money independently to influence our votes. And yet, when a state passes laws that restrict our voting rights, we don't get the same protection as voters on those restrictions in the law that the corporations enjoy. Because if they have a First Amendment right, that's subject to strict scrutiny, which means the government, the state, or the federals have to show a compelling state interest that's narrowly tailored. But when it comes to restrictions on the right to vote, we have this balancing test called the Anderson-Burdick test, where they measure the burden on the right to vote versus the interest the state has in restricting that right. So I think if we started looking at the right to vote as a First Amendment right more, because it is our voice in government, and tried to use the right to vote as a First Amendment right, and I have an article that came out last year in the Yale Law and Policy Journal, which goes through all the Supreme Court cases that really talk about the right to vote as a First Amendment right or as a voice speech right, because I think we do need to change the narrative and really develop the jurisprudence around that. We actually, in the photo ID case in Texas, we had a First Amendment claim in our complaint, and the judge agreed that this was a restriction on the ability of people to assemble and to speak out. The restrictions actually violated the First Amendment. So I think we can get some traction here on this issue. So, so stay tuned on that. We'll have more to say. Leah Aiden with the NAACP Legal Defense Fund, my comrade in arms in the photo ID case in Texas for the last few years. Tell us about your work, particularly the work of LDF and so many other groups that are litigating cases, and what impact Shelby has had since 2013, because John Roberts said we were now in a post-racial era, there was no longer any discrimination. So I assume that you guys don't have any cases going and that none of us are busy?
That's exactly right. And before we get into those details, Jill wanted me to remind you, just as an administrative matter, to sign in for CLE credit. So I'm let her know that I fulfilled that job today of reminding you. So I'm very happy to be on this panel, and though it's Saturday morning at post 9:15, I think all of us love our work, love this issue. I mean, I love the Voting Rights Act, love the NVRA, love protecting the right to vote, in part because, as Julie set up, we know what it has taken to get us where we are today, which is not at the finish line, but we're very cognizant of the people who died for the right to vote, who lost their jobs, who faced real barriers in their lives to protect the right to vote, because they knew it just wasn't about casting a ballot, but that it was about putting in place people who make decisions that do impact their lives. And I think the Ferguson example that we've all become aware of really highlights that when you have people in power who make decisions about who is the police chief or where resources are in your community, where schools are built, what finances go into schools, those choices are the reason why voting matters. And I think part of the conversation, in addition to what Julie mentioned, is talking about the right to vote and reframing it, is really educating folks about why it matters, because not enough of us are participating, in part because we think we just get more of the same. With each election, we just get more of the same. But there is social science that talks about how bringing more and different people into the fold, into the political process, does change the outcomes in terms of policy making and otherwise. So I just wanted to add that on to the conversation and say that it's a pleasure to actually be here and to be talking about this. And I want to layer on what Jerry and Julie have been talking about, particularly with respect to the Voting Rights Act, because it cannot be said enough that the 2013 decision in Shelby County did expose people of color to more abuses in voting discrimination. It left them unprotected in ways that we are seeing years later, and it begs the question of what are we willing to do to get that protection back, because it is sorely needed. Although we've been successful, as Jerry mentioned, in some of these affirmative cases under the Voting Rights Act, Kathy in North Carolina, Jerry and our groups in Texas on the photo ID and in the redistricting, years later, millions of dollars later, with elections taking place under the photo ID law until 2016, between 2013 and 2016, elections taking place under a law that 5 different bodies of courts, 5 different decisions have said are discriminatory. Something about that process can't be the process that we're comfortable with, because those are millions of votes lost. Those are elections that have taken place, people who have gotten into power and gotten the benefit of incumbency, decisions being made all the while impacting their lives under an intentionally discriminatory law, and we're only now catching up. And just to add on to Texas, right, in 2016, there's an interim remedy that says that you have to provide a means by which people who don't have one of the limited forms of photo ID law to vote. What does Texas do after knowing that their law is intentionally discriminatory? At the end of May, it passes a modification of the existing photo ID law, where the architecture is essentially the law from 2011, is essentially the same law, and they think that that's sufficient to respond to a finding of intentionally discrimination. And so we are battling, and we don't know how long this is going to take, battling to come up with a decision that will strike that law down, like the Fourth Circuit did in North Carolina, and to put a mechanism in place to keep Texas from coming up with new poison, old poison, and putting it in new bottles. We're now on the forefront of trying to do that, and I'm going to get into how in a moment. And one other detail with Texas that I wanted to add on is when Julie talked about the literacy test and the poll taxes and the property requirements that were part of Texas's past. We were able to demonstrate through using an expert historian that is the very same justification, this purported voter fraud, this protecting election integrity, the same justification that we've seen for hundreds of years or for at least a century in Texas. So this same justification has been so powerful that even when it passed a law in 2011, Texas felt confident enough to use that same justification to pass a whole new regime, and that is part of the conversation that we're continuing to have to change. And I think we were successful through the litigation over the years and getting out there that this voter fraud doesn't exist. And now with this president and the administration and these new lies, we're back at square one with trying to say, no, there is no voter impersonation. So Texas is a really great example of using a same purported rationale over and over again to justify discrimination. It's a great example, the photo ID and the redistricting litigation, of how inadequate Section 2, these affirmative tools are, even when they're successful, because elections are ongoing under discrimination until you can uproot them. And it just sheds a light on we need something more to protect the right to vote, because we simply can't do it all affirmatively in federal court using the Section 2 in the Constitution. Julie also teed up that with the loss of Section 5, wasn't just this loss of protections for statewide changes, but it really was the impact at the local level. So the media covers the Texas photo ID law. The media covers the redistricting decisions. It covers all of the foolishness that's happening in North Carolina because it's now ground zero for some of voting discrimination. But what happens at the local level through annexations, through changing the days of an election day to make it in a time that they know where Latino and Black voters are less likely to participate? What happens when you change candidate qualifications? What happens when you close polling places or you move them farther away from communities that don't have transportation? What happens when you implement redistricting plans that dilute Black and Latino voting power. I mean, that's really the work of Section 5, as Julie teed up. And we simply just don't know everything that has happened. Our organization has documented in a report what we can from media, from what our communities tell us, from looking at litigation dockets, but there are thousands of voting changes that were blocked each over the course of a 25-year period by Section 5. And we do not know those thousands of voting changes that have happened since 2013 and to the present. And so much of that discrimination is going on under cover of night, and that is one of the major losses. But I want to continue to pick on Texas a little bit more today to give an example of sort of this local, the changes at the local level and how devastating they can be on political power for Black and Latino voters. So we'll turn to Pasadena, Texas, which again has gotten attention from the media because it's making history in some ways. But there are Pasadenas that are happening in Georgia, there are Pasadenas that are happening in Alabama, there are Pasadenas that are happening in North Carolina, and these, again, are local changes impacting people's lives. So Pasadena had an electoral method that included 8 single-member districts for electing its members to its city council. And between 1992 and 2013, it had single-member districts, some form of, and some Latino majority districts within that plan. Shelby County comes down, and what does the city council decide to do? It decides to move to a hybrid plan, a mix of single-member districts and at-large voting. At-large voting allows every eligible voter in the entire jurisdiction in the entire city to vote. And while at-large voting is not per se illegal, we have seen in jurisdiction after jurisdiction in the South, in the presence of racially polarized voting, which still exists in the South, where white voters tend to vote for certain candidates and Black and Latino voters tend to vote for other candidates. And when you're the racial minority in an at-large system, your vote is diluted. You simply cannot elect your candidate of choice because it doesn't square with what the majority of voters prefer. That continues to exist in places like Texas, in places like Alabama. There has been some progress in places like North Carolina where there's white crossover voting, and there are enough white voters who share the similar voting preferences as Black voters that you don't necessarily need majority-minority districts in those places, but that is not necessarily the case in places, again, like Texas, Louisiana, Alabama, where patterns remain stark. So again, at-large voting is not per se illegal, but with racially polarized voting, Latino voting power is diluted in that system. And courts knew that, which is why, or the Section 5 knew that, and that is why it required Pasadena to have these single-member districts for so many years. But Shelby County comes down, and Pasadena says, I'm going to revert back in some form to a system that I know is going to diminish the growing power, the ever-growing power of Latino voters in this city. And fortunately, a district court and a judge who some would consider conservative said, no way. No way. This law is intentionally discriminatory, intentionally designed to diminish the voting power of Latino voters under both the Constitution, the 14th Amendment, and Section 2. And it immediately requires Pasadena to be bailed back into the Voting Rights Act, making Pasadena the first jurisdiction following Shelby to be bailed back into the Section 5 preclearance requirement. One other jurisdiction in Evergreen, Alabama, voluntarily agreed to bail in following litigation, but otherwise Pasadena is making history. Now, Jerry teed up that Texas loves to appeal, and Pasadena has appealed the underlying finding of discrimination. It hasn't challenged bail-in per se, but Texas, knowing the writing on the wall in the redistricting case and potentially the photo ID case, files an amicus brief in that appeal and says bail-in was inappropriate, and essentially says that one constitutional violation is not enough to be bailed in. Under Section 3C, this bail-in provision, you have to establish a violation of the 14th or 15th Amendment, which is the case in Pasadena under the 14th Amendment. And Texas says you have to have serial violations. You have to basically revert back to what it was like in Jim Crow days in order to be bailed back into the Voting Rights Act. And that is not what the Voting Rights Act requires. That's not what Section 3 requires. It also tees up the similar arguments that we heard around Section 4B, that this is an overreach, that this is far too much imposition of a federal court to impose preclearance back on a local jurisdiction. The same arguments that we heard before. Jerry's organization, the Campaign Legal Center, and LDF filed a brief in support of bail-in in that case, arguing that Pasadena is the quintessential jurisdiction that needs to be bailed back in, reverting back to a method of election that they know to be discriminatory when they know that no one is going to be observing them, and doing so in the presence of growing Latino voting strength. This is what the Section 3C was meant to do, is to capture that pocket of discrimination and allow courts and or the DOJ to have the discretion to review their voting changes for a temporal time. So in Pasadena, all voting changes dealing with the city will be scrutinized by a federal court or the DOJ, likely the DOJ, until 2023 if the bail-in is upheld. What is important about that and what distinguishes it from 4B is that, again, it's based on a recent constitutional finding of discrimination. It's temporally limited for a period of time, and the record establishes, in our belief, that it's appropriate for the court to use its discretion to look at all voting changes impacting that city, given the record in that case. These bail-in is something that is being sought after in the redistricting litigation. It's something that we're seeking in the photo ID litigation because, again, we see Texas implementing a photo ID law in 2011 that's intentionally discriminatory, and then going back into the legislature years later in 2017 and just tinkering around the edges and not really doing anything to rid itself of intentional discrimination. And so we are seeking bail-in there. But it is a wholly discretionary remedy, and again, going to North Carolina, it's one that these courts do not have to impose. So North Carolina was successful in striking down that monster law, but the Fourth Circuit declined to order bail-in for that jurisdiction. So even though it won the success of the striking the whole law down, that the legislature, as it has said it is going to do, is free to go back to the drawing board without necessarily getting the scrutiny of a court or a federal government, but requiring lawyers like Kathy, like the Southern Coalition for Social Justice and others to go to court and to seek injunctions or to otherwise fully litigate some of those cases in order to be able to stop, again, this scheming of one thing after the other, getting stopped from doing discrimination and then just coming up with the next law. That's what we're trying to get ahead of through bail-in. I also wanted to just add the detail that bail-in was a not often remedy that was used prior to Shelby County, in part because we had Section 5 in place, but bail-in had been used. There were a number of consent decrees that were entered, and there was one case litigated out of Arkansas when former President Clinton was the governor that shows, again, the dexterity of bail-in. What was being challenged was an apportionment plan, but through that litigation, the court imposed bail-in for majority vote requirements. So something that wasn't even directly challenged by the litigation ended up being bailed in. And that was a statewide bail-in. But consent decrees over a number of years before the Shelby County decision led to bail-in of various jurisdictions across the country. But nonetheless, it's a very exciting area of the law in some ways because it hasn't been readily used. But because we know that we have to get back to some form of preclearance in these places that are going to use adaptive strategies to discriminate, bail-in is the tool that we have at this point to seek what we lost with Section 5. LDF is litigating a challenge to Alabama's photo ID law. implemented, passed prior to Shelby County, but held at bay until the Shelby County decision, implemented thereafter. We're seeking bail-in that case. I filed post-trial briefings just yesterday or Thursday, I don't know the time, in a challenge to an electoral plan for a state court in Louisiana, and we want to bail back in that jurisdiction. Our friends at the Lawyers Committee are challenging mid-census redistricting in Georgia and want to bail in Georgia through that litigation. And so all of this affirmative litigation that you're hearing about under the Voting Rights Act and in the Constitution that is occurring is using this remedy of bail-in to get those bad acting jurisdictions in the Deep South that were formerly covered by Section 5 back into that regime, that protection. But similarly, bail-in, as I should have mentioned at the top, is a nationwide remedy. So you could seek it in Ohio, you could seek it in California, you could seek it in New Hampshire, you could seek it anywhere where you get a constitutional violation and the court uses its discretion to order bail-in. So there's more to come on that, and again, it's I think very exciting to see what will come in the next year or so with these bail-in remedy requests. Turning back to these local voting changes, one of which was emblematic by what Pasadena did, the Leadership Conference in 2016 put out a report of polling place closures and found that as of the 2016 elections, nearly 1,000 polling places were closed in the places covered by Section 5. And again, this is the type of thing that goes on closing polling place closures, consolidating them, turning them into voting centers. Doesn't get a lot of news, not that interesting unless it turns into a big fiasco. But it is impactful for the communities that we serve because having access to a polling place in your community that you can walk to, that you can bike to, where you don't have public transportation, is a means by which people of color, again, access the ballot. And there's nothing necessarily wrong with closing polling places, moving to voting centers in certain scenarios, but what that report demonstrates is that those polling place closures, again, were allowed to happen without any scrutiny. And in the 2014 primary elections in Maricopa County in Arizona, right, polling places were converted into voting centers, and they were done so without any real analysis of what the turnout might be, what long lines might be created by this, whether there were sufficient voting centers. And so the news capture the long voting lines and the disenfranchisement that happened in those elections. But with Section 5 in place, in places that are closing polling places, someone would have had to ask those questions about what happens if you convert to voting centers or you close polling places. Someone would have had to ask questions about, hey, if counties are doing this to save money, does that saving of money outweigh the loss of the right to vote, the fundamental right to the loss of vote? All of those questions would have had to have been asked, but they don't have to be asked for the most part in places unless we do what we're asking you and others to do, which is to be engaged at the local level just as much as we're asking you to be engaged in state legislatures when you know that things are occurring. So some of the takeaways that I would ask of you, because we were supposed to give you some homework, are to help us document voting discrimination. We lost notice. We don't know everything that's happening, but if you learn of things that you think are potentially discriminatory in your community, tell a local reporter, tweet us about it or email us about it. Contact people and highlight it, and we can investigate whether we think it's discriminatory. There was a handout passed out of common discriminatory voting changes. It's the same ones that we have seen time and time immemorial, sometimes new things like photo ID laws, but for the most part, the same types of changes. Tell us about them. But similarly, go to the places where these things are being debated, whether it's a school board meeting or a county commission meeting or a state legislature, and put on the record a letter that says, we think this could be potentially impactful. We think you can amend it or make suggestions that would lessen or rid the discrimination from whatever is being proposed. And at least when we go to litigate it, we have this record in place that someone tried to tell them to do otherwise, and they continued on the same course. We also, at LDF, do a lot of demand letters, and these are meant to forewarn jurisdictions that we're watching them and that we potentially will bring litigation if they are violating the Voting Rights Act or the Constitution or other relevant law. And we always need law students, lawyers, and others to help us write these demand letters. And those can be effective. Many of these local jurisdictions in particular don't like the press, don't like the sunshine. And so doing these letters can be a means to stop changes before they go into effect. But again, if they do go into effect, it's further documentation that we forewarned you and you still took that course of action. And finally, I would say two other things that you could be doing, which would be to join us in litigation. Section 2, affirmative litigation, it is not a replacement for a pre-clearance mechanism, and there simply has not been enough resources dedicated to bringing as much affirmative litigation as we can bring. But it requires lots of money, and it requires an investment of years, frankly, because that is what this type of affirmative litigation ends up being when it's filed. And lastly, Julie teed up what we can be doing at the state level, and we know that there are many dysfunctional state legislatures as much as there is in our federal government. But California continues to serve as a model of a state that has its own Voting Rights Act, and that has been responsible for, in large part, making jurisdictions with increasing Latino and Black voting strength have single-member districts or the ability to elect in majority-minority districts, among other things, and that still serves as a model for what states can do until we have a federal replacement for the loss of Section 5. And I'm very happy to take questions at the end of the presentation, Justin's presentation.
Thank you, Leah. Thank you very much. I want to quickly show you how great minds think alike, I guess. When Leah talked about if you know of something, or even if you have a question like, hey, they're doing something in my city, or my uncle called me from Macon, Georgia, and said that they're annexing white neighborhoods because they're afraid blacks are going to take over the city council, which we've had stuff like that, not in Macon, but other places. You can submit a question or a complaint to the Voting Rights Institute to look into it. And the lawyer will actually do something and check into it and gather the facts and see if they're, and sometimes write a demand letter, as Leah says. The other is that we do have to change the narrative, and you can see down at the bottom there, I say we have to create an alternative narrative about the right to vote and vote suppression, which is what Julie was talking about. Maybe we need to create our own commission, a counter to the Voter Fraud Commission, where we talk about, where we develop that, where the right to vote is voting is speech commission. But you can also serve as poll workers, poll watchers, and election protection volunteers. There's lots of opportunities out there. So we've been talking a lot about race, ethnicity, language minority groups. But there's also a lot of voting changes, voting practices out there that can be challenged on grounds other than race. And just to underscore a point before I turn it over to Justin to talk about that topic, I want to mention that one of the things that we find really important all of a sudden, not that it wasn't before, but now, especially when you look at what the Supreme Court just did a week ago in upholding this, racial gerrymandering findings out of North Carolina, is the court relying on Rule 52, how important Rule 52 findings of fact are. And of course, those are always important. And I'm not going to go out and on a limb here, but I'm not letting any cat out of the bag when I tell you that it's really important who the district judge is, because the district judge is going to write the findings of fact, and if you win, you have a good chance, I think a better chance of upholding your case in the Court of Appeals than you do when a judge on the other side maybe doesn't write good findings in your favor. It really opens the door for the Court of Appeals to look at those findings. But so I just say, the other thing is I want to underscore there's the fact that how important attorney's fees litigation is. If you're the prevailing party in these cases, in a voting rights case, you can, as the prevailing party, you're entitled to attorney's fees. We always get the attorney's fees reduced, Courts always think the rates are excessive, or maybe there's duplicative work, and they nitpick every timesheet that you ever had going back 6 years. So, but nonetheless, as Leah said, it's really a costly undertaking. These cases, statewide cases in particular, take a lot of time and effort. And that was what really, one of the other impacts of Section 5 was to force us into affirmative litigation. But we've so far have been pretty successful in recovering a fair share of our attorney's fees and costs, particularly expert witness costs, which run into the hundreds of thousands of dollars. So I'm going to turn it over to Justin. And Justin, tell us if we can also bring cases to protect voting rights without necessarily have to relying on a racial or ethnic basis.
Yes, and
Okay.
plenty.
Thank you, Justin. And we'll now.
And so I welcome questions. So I want to thank, before I really get into that, I want to thank the American Constitution Society as well. I want to thank all of you tremendously for devoting a little bit of your Saturday morning to it. We all here on the panel think this is one of the most, if not the most important thing there is, because it underlies everything else. You want an infrastructure plan. This is the infrastructure for how the infrastructure gets done. This is how we build the world we want to live in. And so thank you for taking a little bit of time to help us do that. The other thing I want to thank is I want to thank Jerry for putting me at the end of this panel. Leah gave me a shout out to California. I had the great honor of serving in DC for a while, but I'm now back in California. So coming in from the West Coast, the panel started at 6:15 and we are cooking on towards 7:40. And by now, I've had not only a few cups of coffee, I've had the verbal caffeine shot that comes from listening to Jerry and to Julie and to Leah. And so I hope you all, even after this long time, are as awake, as woke as I am. The right to vote is for everybody, and there are many ways to make sure that the right to vote stays for everybody, and that's not abstract. Too often we think about that as abstract. I think Julie, and by the way, let me preface all of this with a comment by one of my favorites and another favorite of both this organization and the session, Pam Carlin. She remarked that at the end of a panel, she often remarks, at the end of a panel, everything has been said, but not yet by everybody. So I'm going to repeat, or at least echo, an awful lot of what you've already heard, because I agree with the vast majority of everything that's been said here. That's what you don't agree with. We'll get there. So Julie in particular mentioned that the right to vote is not abstract. It is about power. It is also, even when it is not about power, and it's always about power, even when it's not about power, it's about mattering in the community. It is not theoretical. And if you ever want to prove that to yourself, go talk to somebody who tried to vote and was told they couldn't. And you will see how viscerally powerful this one thing that we all get to do as members of the American citizen community. P.S., we don't all get to do it as members of the American citizen community. There are a lot of people who are locked out. Talk to them and see whether it matters to them, even when they're not making legislation. See whether the right to vote matters to them. It is among the most emotional responses you'll get, and there's a really good reason for that. The Voting Rights Act is a key part of that story. I mean, imagine you're getting beaten with billy clubs, and the thing you're marching for is the right to vote. That says a lot. And we are now 52 years in to the Voting Rights Act. Because I don't want to lose this point, the Voting Rights Act is immensely important, and rightly so. We are also 42 years into the Voting Rights Act. And when the Voting Rights Act was amended in 1975, for millions of Americans, that amendment was every bit as important as the original. And because so much attention is correctly put on Sections 2 of the Voting Rights Act and Section 5 of the Voting Rights Act, which we already talked about, I want to mention some of the other pieces of the Voting Rights Act because they are also immensely important. So in particular, Section 203 of the Voting Rights Act came in 1975, and that was the piece of the Voting Rights Act that says you are a full member of the American community no matter what language you speak. It provides language access rights to millions of American citizens, and it reflects a very distinct view of our heritage that I think we share. It recognizes that the first people here did not speak English. It recognizes that the first Europeans here did not speak English. And it recognizes that people keep coming here to join the American community who do not speak English. And it provides voting access to all of them too. It is immensely important. And I think only because the rest of the Voting Rights Act is also immensely important, it gets underemphasized. But it is a profoundly powerful provision of the Voting Rights Act and affects a lot of places in the country where you might be surprised, right? Language access, there's a responsibility to give language rights, to provide communications and materials in languages other than English in places like, yes, Texas and Florida and in Alaska, and also places like Massachusetts and Kansas and Connecticut, and places that might not immediately come to mind, but where if you look at census data and if you go out into the community, you will find an awful lot of people who are American citizens who don't speak English as well as their native languages. And the Voting Rights Act actually gives them protections too. Another provision of the Voting Rights Act is also immensely powerful in this regard. It's Section 208 of the Voting Rights Act. And it says that if you have difficulty reading or writing in English or have a disability, that you can get help in the process. That you can seek and receive assistance from anybody who's not your union boss or your employer and come into the polls with them. There is an enormously important case, also out of Texas, and I promise you, Texas, yes, is what we like to refer to as a repeat offender. But we all do work outside of Texas, too. Nevertheless, because Texas has particular problems in this arena, it comes up a lot. And another one is in a case that's right now at the Fifth Circuit on Section 208 about the type of assistance that people can get and when they can get it. But this is the provision that lets mom ask her kid to come with her into the voting booth to help her out. This is the provision that lets grandma ask somebody who's waiting with a "do you need help" sign outside the polls to come into the polls to help her out. It's enormously important for the way that we each exercise our right to vote. And it is every bit as much a civil rights statute as Section 2 of the Voting Rights Act. The NVRA, and I'm delighted that Julie mentioned it as a watershed, because it was and is, and hopefully will still be. Chris Kobach has had his sights out on the NVRA for a long time. For those of you that have been following, he is the co-chair, and Jerry had this slide up before, he's the co-chair of the new commission to investigate stuff about things.
I'm going to have more to say about Chris Kobach in a few minutes.
He was photographed with President Trump early in the transition period outside of a meeting he had, his audition to be Secretary of the Department of Homeland Services. He forgot to put his notepad in his folder, and so was photographed with a piece of paper that had a lot of bullets on it. There's one in particular you should pay attention to: draft amendments to the national voter, and then his sleeve covered up the best of the bullet. But there's only one thing that starts national voter, and it's the National Voter Registration Act. It's motor voter. It's what Julie was talking about. So the amendments have been drafted. Mm-hmm. And it's going to be up to us to make sure that if the amendments don't make sense, they don't go anywhere. Because the NVRA is also a civil rights statute. Too often, I think we think of the Voting Rights Act as the statute for people of color, and the NVRA as the statute for white people. And the same underserved communities that are served by the Voting Rights Act are also immensely well served by the National Voter Registration Act. You want to know who is not able to get the registration opportunities they deserved when they go to a driver's license office in Alabama? There are plenty of poor minorities in that list. You want to know who is not able, and by the way, that now, thanks to action on the NVRA, has largely been repaired and is much, 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 much better. Alabama's got a couple other problems, but that is much better, and tens of thousands of people are getting opportunities to register when they interact with the DMV that they never had before. There's been ongoing litigation in Louisiana, including some brought by the LDF, including some brought by the Justice Department, that is making sure that offices that provide social services, public assistance, are offering the opportunities to register that they deserved. And you want to know who's helped when people on the welfare rolls in Louisiana, one of the largest welfare systems in the country, actually get opportunities to register to vote? That's not just white folks. So these are enormously important statutes for all of us. And again, deserve more attention than they get, although the attention put on all the other statutes is important and justified because those are important too. There's a case coming out of the Supreme Court. Just decided to grant cert on a case out of Ohio about a different part of motor voter, of the National Voter Registration Act, when you can purge people. And in particular, the question here is, can you purge somebody when there's no evidence that they're ineligible? Can you purge somebody when the only evidence you've got is they haven't answered your mail? Ohio says yes. Advocates say no. Supreme Court just agreed to hear that case, and it too is more important than you might think. There are other causes of action as well beyond statutes. Many of the cases that have been talked about already have been brought under the Constitution. There's a raft of racial discrimination cases that are now underway or have just been concluded. There are also challenges based on the notion that a particular statute or particular regulation creates an undue burden on the right to vote, that essentially the harm isn't justified. And there, as Jerry mentioned, it's a balancing test. There are state constitutional causes of action as well, and there have been increasing lawsuits brought under state constitutional provisions, some of which follow the federal constitution, some of which don't. And state statutes also speak to some of the policies that have been passed. Notably in Kansas, there have been a number of challenges on state law grounds that have stopped regressive and restrictive policies that interfered with the right to vote. So those are also available. Without going into all of them, because we don't have time to go into all of them, I want to make a global point. We're winning more than we're losing. And you might not get that from some of the coverage, because the coverage rightly focuses on, not rightly focuses, usually focuses on the bad stuff, and there's plenty of it. But we are winning more than we are losing these days. We are winning, as you've heard from everybody, more slowly, more costly. In the meantime, bad stuff is happening while policies are in place that shouldn't be. We've got less information, and we are back to playing whack-a-mole in a lot of ways. Or as one of my colleagues who litigates a lot in Texas says, guacamole.
I'm so stealing that.
But we're winning. And the real point is we are winning. Jerry said he's good at losing 5-4, but even Jerry has been winning a lot recently.
Goes to show you after 45 years, you know, your luck changes.
The reason we've been winning is because people have been bringing good cases. There is an immense amount of work on the ground that goes into each and every win. And here, I also want to issue a warning. There have been bad cases too, and guess what? They are losing. Yeah. And they're making the law worse. They're making it harder for the rest of us to win. Let me give you a recipe for losing. And by the way, before I give you the recipe for losing, Julie mentioned that the NRA challenges everything. Not in court, they don't. Right. They challenge a lot in court, but they push back in the court of public opinion, they push back in legislatures, they push back in a lot of arenas that don't have to do with litigation. The NRA brings cases, and they put the same amount of effort into those cases that I wish were put into every Voting Rights Act case, or every voting rights case that doesn't deal with the Voting Rights Act. I'll give you a recipe for losing. Bring a case that's totally abstract, that depends on a contested reading of the law. Don't show any harm. Don't talk to actual voters.
Crawford.
And think that a judge, even a good judge, can fix what you don't give them. The amount of work on the ground that goes into winning cases is often lost when the report comes out that the case won. But there's a very good reason that each and every one of those cases won. And there are cases being brought that are going to lose, that are designed to lose, because the care hasn't put into them. that people think it's as easy as filing a complaint, and then you find a good judge, and magically the case resolves itself. And that is almost never true. There's also plenty of non-litigation, and Jerry's mentioned some, and Leah mentioned some, and I want to emphasize this as well, because it can be tempting when anyone is a lawyer, to forget that they often call you counselor. There's a reason for that. It's because you have skills beyond filing complaints, beyond litigation. And litigation is often the last choice. It's long, it's hard, it's expensive, and there's real risk of downside if you lose. We're winning in non-litigation stuff too. More slowly, more costly. But Julie mentioned some successes in automatic voter registration and other fixes to the voter registration system. If you talk to election administrators, local election administrators on the ground, some statewide officials, but really talk to locals, these are people who desperately want the trains to run on time because they hear it when they don't. They don't have the budgets they need. They don't have the support they could use. And they want common sense adjustments and fixes and improvements to the system the vast majority of the time, no matter who put them into office and no matter what party they're with. There is remarkable agreement around some of these provisions to make the voter registration system more efficient, more effective. And by the way, the same things that get people on the rolls and keep them on the rolls also make the rolls more accurate, so everybody's happier at the end of the day, also cost less money. And that is truly a recipe for success, and you can influence that. In fact, some of you have influenced that already in state houses and in local election departments across the country, in counties. There are still plenty of problems. We are winning, but there are still plenty of problems to fix. Julie mentioned Bush versus Gore. Go back and look at the coverage of all the things that weren't hanging chads in 2000. They are all still problems. Every single one of them. And there are about 25 or 30 things on that list, things that we realized in the election of 2000 could impact a presidential election. That was overdetermined in every possible way. Leave the hanging chads aside, and there were plenty of problems we have not fixed yet. And they all need fixing, and most of them aren't going to be fixed through litigation. Most of them are going to be fixed by advocating for policy change on the ground, or giving administrators the tools they need to succeed when they already know what they want to do to fix it. We are in desperate need of people who get information across, whether it's not litigation. So you heard Leah already say one of the big challenges with the loss of Section 5 is we don't know what's going on in local communities as well anymore. So go to city council meetings. Go to county commission meetings. You all understand what's going on there far better than most because those are also tools you have. So understand what your local government is doing. It affects a lot more than you think. And finally, I am overjoyed at the first thing on Jerry's list because it's the thing I always end up with. You have the opportunity to be a government official for a day, and there is absolutely no excuse for passing it up. Be a poll worker. You can study the law in the state, you can study the law in the county, you can study the law in the local jurisdiction and municipality, and the law on the ground is made by people who sit behind desks and decide whether you can or can't cast a vote. That could and should be you on election day, and that should be all of the people who similarly care about people being able to vote, because the thing that matters most when you hear about people who want to vote and can't is generally the interaction between them and the person on the other side of that table. And so if you want to have that very visceral feeling of making this most tangible right absolutely as effective as you can, you have a very active way to stand up and make sure that's possible, and that's to take part in the process from the other side. So I heartily encourage you. I am overjoyed. There are a lot of good things you can do, but that is number one on the list for a good reason.
Thank you, Justin. One of the interesting things about having people like Julie and Justin and Leah on the panel is that, you know, they all have been involved in litigation. The three of us have all been in the Justice Department, where I spent 21 years. And I will tell you, in Leah's LDF, you know, started back in the day with Thurgood Marshall and so many other great lawyers, is that it's all about the preparation of the case. And it's all about getting out the facts. So your point, Justin, about if you want to make bad law, file a challenge to, make an abstract challenge to a law that has not yet been implemented and don't present any live witnesses. I mean, one of the best things that I ever did as a trial lawyer, I think, was in the Texas photo ID case when we had a client who was a wheelchair-bound veteran who had been voting for years and years, an elderly man who got pushed into the courtroom by his son, who was probably about 40 or 50 years old.
With an American flag on his wheelchair.
Right. And he testified that he had been voting for years, and in Texas they have curbside voting. So the person came out and said to him, "Mr. Carrier, are you here to vote?" And he said, "Yes, I am." And they had the little machine, and they said, "Well, you know, you have to present a photo ID now." And he said, "Well, I have a photo ID. I have my veteran's card," which actually was one of the cards that was supposed to be good. And she looked at the card and she said, "Well, you've been a veteran for so long that this is faded and I really can't see you in this picture." And he said, "Well, yeah, but you know it's me. And the whole purpose of the ID is to establish my identity. And we've done that because you called me Mr. Carrier and that's who I am." And she said, "I'm sorry, I can't let you vote." And he didn't vote. And
Become a poll worker.
right. So what ended up happening was when we called Mr. Carrier as a witness and he got wheeled in, he told this story, right? And he told about what happened. And you could say that that testimony is really important and it was compelling to the district judge. But the best question was, after he got done, how did that make you feel when you were denied the right to vote? And after about 2 minutes of his lips, bottom lip quivering, he couldn't answer. It was that emotional and that important for somebody who had fought for his country and the right to vote. So as a trial lawyer, you can develop those facts and really make them meaningful to federal judges. And I will tell you, the federal judge in that case, Judge Ramos, I think she really felt moved by that testimony. Who wouldn't be? You know, same thing when we had a woman up there testifying about the fact that she couldn't afford to get a birth certificate because it costs like $60 because she was born in another state to get a certified copy of her birth certificate that she had to present in order to get the free ID, which of course we contended was a poll tax, but the Fifth Circuit said otherwise. But here, get this. So Texas cross-examines this poor woman and says, "Well, let's talk about your monthly income and see if you really can't afford $60 on the witness stand." And goes through a woman whose monthly income is about $300. And by the time they go through all her bills, she only has like $5 left at the end of the month. And so they say, "Look, if you just saved for 12 months, that $5, you'd have the $60 for your birth certificate." And she, you know, you can't teach witnesses to give answers like this. She says, "You know what, though? You forgot something. Food. You can't eat a birth certificate." What a great line. Not coached, but those are the kinds of facts that you need to bring out in these cases. I will say, you know, we have a case pending in Alabama right now challenging the Alabama felon disenfranchisement law. About 25%, I think, of African Americans in Alabama are disenfranchised because of a felony conviction. And the felony conviction, it arose out of the Constitution of 1901, which, as you probably know from history, was not a good year for African Americans in Alabama. Not that there's really any good year for African Americans in Alabama, but in 1901, the disfranchising Constitution, they passed an amendment to the Constitution disenfranchising all persons convicted of a felony of a crime, not a felony, a crime of moral turpitude. And somebody said, "Well, what's a crime of moral turpitude?" And they said, "We all know those. Those are the crimes committed by, quote, colored people," close quote. So that law was on the books from 1901 for decades. And finally, it was challenged as discriminatory, and the Supreme Court found that it was, U.S. Supreme Court, with challenge brought up. So what does Alabama do? Do they go back and enact a responsible law? No. They enact a state law, not the Constitution. They say, well, our Constitution got struck down, so we'll just impose a statute now that says if you've been convicted of a felony of moral turpitude, then you're disenfranchised. Do they define moral turpitude? No. Do they say it's committed by, quote, colored people? No, they just don't say anything. So what happens is we go into Alabama, we talk to the community, and the community says, this is the real big problem in Alabama because we don't even know what crimes of moral turpitude are. So we go interview people convicted of a felony, and they'll say, well, look what happened to me. I committed a felony, I went to go vote, and the person said, well, I can register you, but you say you have a felony conviction. And he says, yes. And she says, what is it? And he says, well, I was convicted of possession and distribution of marijuana. And she says, well, that's not a crime of moral turpitude. So she registers him. So then he moves to another county, and he goes to the county, and he says, when he goes to register, he says, I want to make sure you know that, I was convicted of this crime of possession and distribution of marijuana. And the registrar says, well, that's a crime of moral turpitude. You can't vote here. So there's a whole equal protection problem there, and we're litigating this case, and the state has filed a motion to dismiss. But here's one thing that can happen. We filed a lawsuit. Alabama legislature 2 weeks ago amended their state law to define moral turpitude by saying, here are the crimes of moral turpitude. Interestingly enough, the recent sex scandal with the governor and all that's not a crime of moral turpitude, apparently. So it's not listed. Nor is any really public corruption crime a crime of moral turpitude. So like the Speaker of the House, who was, bribery and in jail, that's not a crime of moral turpitude. But, well, stay tuned. We're still litigating that, and it'll probably end up in the Court of Appeals in the 11th Circuit. And similarly, one final point on Justin's observation about non-racial claims that you can bring. So we had a case, and this involved the Lawyers Committee and a bunch of other civil rights groups. We all filed suit against Georgia last year in 2016 because Georgia all of a sudden decided, well, we're going to look at every voter registration application and we're going to compare it to the driver's license database. And if there's a difference in those two things, we're going to tell the person they're rejected. So here's my name, J. Gerald Hebert. My first name is Joseph. On my driver's license, it says Joseph Gerald Hebert. On my voter registration form, it lists J. Gerald Hebert. So if I went to register to vote and I put in J, I would be rejected. 80,000 people they rejected last year. And when we got wind of this in the late summer, we filed a lawsuit and a motion for PI, and the Texas AG's office that had not been involved in the Secretary of State's decision to do this came to us and thankfully said, we'll consent to the preliminary injunction. This is outrageous, basically, is what they acknowledged.
Just to clarify, you said the Texas AG's office
Oh, I
came
meant,
to you.
sorry.
And just because that sounded implausible, the Texas AG's office would have come to you and consented to anything. I just wanted to...
The Texas AG's office is always coming after me, so I'm very paranoid. Ever since I testified against Jefferson Beauregard Sessions, I feel like I walk around with a bullseye on my back. But Jefferson Beauregard Sessions the third, I should say. So anyway, real quick, we will take questions. Before we do, I just want to talk about this federal commission that the president has announced. If you look at the three things that are supposed to be reported, it doesn't give you a lot of hope that you got those laws, rules that enhance the people's confidence in the integrity of the election processes. So what that'll do is they'll say, oh, photo ID laws, they enhance the people's confidence in the... Because look, I have a poll here where they ask people, do you believe a photo ID law should be imposed where it guarantees everybody has the right to vote and we know that everybody will come to the polls and have an equal opportunity to vote and that no person will vote who's illegal? And of course, about 89% of the people who look at that question first go, what does that mean? And everybody then says, yeah, I think that's good. So they'll cite some polls like that to justify vote suppression laws. How about those that undermine the people's confidence in the integrity of the voting process? Well, that would be minorities voting. That would be one that undermines people's confidence, probably. And hackers, yeah. From Russia, yeah. I don't think that'll find their way into the report. those vulnerabilities that could lead to fraudulent voter registration, the Mickey Mouse example I gave before. Real quick, here's who's running the Voter Fraud Commission. Chris Kobach, Kansas Chris Kobach. Get it? K. All right, just saying. So if you look here, I've got this came all from Project Vote Summary that they put online. He was counsel to the Immigration Reform Institute that's been labeled by the Southern Poverty Law Center as a hate group. And their founder, I've come to the point that for European American society and culture to persist requires a European American majority, and a clear one at that. As whites see their power and control over their lives declining, will they simply go quietly into the night, or will there be an explosion? Featured speaker at a workshop. A publishing house routinely puts out race-baiting stuff penned by white nationalists. The Social Contract Journal is edited by a white supremacist council. The hate group, by the way, that Dylan Roof ended up following and then murdering 9 churchgoers. Sued Kansas over a law that granted in-state tuition to high school graduates that were born to undocumented immigrant parents. Court rejected that. As you point out, Justin, we've been winning a lot of these challenges over the years, and more recently. By the way, the state court litigation, really important point, because I think, this is just a hunch on my part, the federal judiciary might be getting worse in the next few years. So I think we're probably going to see some state court. I'm going to leave it at there and bring the questions up. We'll talk more about that after when we're all done. Final point. Remember, let America be the dream the dreamers dreamed. Let it be that great, strong land of love, where never kings connive, nor tyrants scheme. Langston Hughes. We should all go back and read Langston Hughes. Yes, sir.
Hi. At a session yesterday, Paul Smith asked other panelists why the Fourth Circuit didn't do the bail-in. Why didn't it, and what are the costs of its not doing it? And what are there any advantages to its not having done it?
Well, that's a very good question, because there was a finding of intentional discrimination that was unconstitutional discrimination, which is normally a predicate for getting 3C coverage, as it's called, bail-in. I often think that federal judges, and if there are any in the room, I apologize in advance for this comment, but I do think that federal judges anticipate correctly what's going to happen after they make their decision. So I think if North Carolina, which basically took detailed findings of fact made by a federal judge and said those were clearly erroneous based on the evidence that was submitted, and reversed the decision of the district judge and found unconstitutional intentional discrimination where the district judge didn't even find a violation of intent or effect, I think they felt that that would put a bullseye more so on the case when it got to the Supreme Court than by not ordering bail-in, because that's a pretty drastic remedy for, let's face it.
So it was too heavy a lift for them, even as concerned as they were.
They may have thought that, yeah. I think so. I think that's what we find when we litigate cases, that judges do anticipate, well, how's this going to look, particularly when you're in Texas and you got to face the Fifth Circuit. I mean, when we went up en banc in the Texas photo ID case, there's 15 judges up there, and I'm going to just generalize here. 10 of them are bad and 5 of them are good. And so, anyway, we won 9-6. Yes, sir. Next.
Hi, I'm Ruben Garcia from the UNLV Law School, and in Nevada, we have now a Democratic legislature, so we didn't have a lot of the attacks on voting rights, but we still have a Republican governor for the next 2 years, and there is a petition to put automatic voter registration on the ballot in Nevada, and I just wondered if you knew of data that would support this reducing fraud and increasing turnout, so we can use that in the ballot.
There are lots of nonprofit groups, including the Lawyers Committee, including the Brennan Center, including the Campaign Legal Center, frankly. There are lots of nonprofits groups, including the Leadership Conference, that have talked about the benefits, including economic benefits, to things like improving the voter registration system in a number of different ways. I will say, again, local election administrators want to see systems improved. And so you may find a lot of support across party lines. Is also, don't assume that the party label behind somebody's name makes them a fan. Don't assume that the party label behind somebody's name makes them a foe. A lot of these things, when you actually talk to people who run elections day to day on the ground, that can help get support for a statewide change.
You know, there's a report that CAP just put out like 2 days ago, analyzing the impact of automatic voter registration in Oregon. I haven't read it, but I would look there because they likely there is sort of summarize lots of stuff. But I will say my understanding in general is that AVR does not necessarily correlate to increased turnout. But anyway, look at CAP's thing.
Thanks.
Yeah.
Thank you. And I would just add, Illinois just, the governor just signed a bill there that does authorize automatic voter registration. I know there was a big campaign, so I would look into the Illinois example. But these three individuals are going to be, because I'm told we're out of time, so, but please, we have all three.
I work at the other end of this spectrum. I'm actually registering voters in underserved areas of Cleveland and East Cleveland.
Thank you.
And my frustration is that I feel like we're losing. That people who could register don't want to register, and people who could vote don't vote.
Right.
And we spend incredible amounts of hours registering voters, trying to get them, begging them to register, and then begging them to go out and vote. And I would challenge the Open Society Foundation to come up with messaging that would help people understand why they need to register and why they should vote.
And I will take that challenge.
That's very good. Thank you for that. And it's really important that
Because
we
you're right.
tell people why it matters.
You're right, and that's when Leah made that point, is that if people don't feel like, look, there's been a lot of work that's been done, just to say, I know we're out of time. There's been a lot of work that's been done by the people who oppose what we're trying to have happen to try and make people feel like their vote doesn't matter, right? That everybody's corrupt, right? Intellectuals are the bad guys. Government is the bad guy. The system's totally messed up. The system's completely corrupt. A lot of that narrative is about depressing the vote. Because if you feel like you have no power, then why should I be part of this system? And that's a lot of what we saw happen in 2016. So we take very seriously this idea of how do we make people understand that they actually have power if they use it. But we have to do that on the ground with really smart messaging and connecting them to issues that matter to them. I agree with you.
And one
Dude, if they were
other,
mine, you'd have them, but I still have an institution I work for.
and one small point about policy point, I mean, the other devastating thing about North Carolina's law before it was struck down is that it encompassed a restriction on pre-registration for 16 and 17-year-olds. And so laws that allow people to register when they're early are important because it gets them, there's social science data that gets them into the political process early. And so all of that together.
The increasingly concerned looks toward the side of the room, I think, tell us that we should probably...
Can I do, this is so fast, my question is so fast.
Go for
and
it.
it's like a yes or no.
Okay.
Why doesn't a court that finds that there's been unconstitutional discrimination and sends an act back to redo it, maintain jurisdiction over what happens to that act?
Many do.
And they do.
So
They
that's
do.
like almost like 4C, almost, at least
Well,
for
it's
that,
like 3C,
that purpose,
right.
or 3C, whatever.
Right. It is, I mean, after all, that's part of the court's equitable jurisdiction is to ensure that if it finds a violation, that it can impose a remedy. So that'll be the last word. Thank you all very much.